have Shataka Shores-Brools here, who is a senior trial counsel with the Office of the Chief Trial Counsel, and as you all, or many of us know, former ladle with the formerly law office of Alice Iglesias. And then we have her colleague Trinidad Ocampo, who's the deputy trial counsel at the same organization. So they're going to be here to talk to us about ethics.
All right. Well, hello, and thank you guys for attending. I'm going to start with our disclaimer. As an employee of the State Bar, I am not authorized to provide you with any legal advice or counsel or render a legal opinion. Neither my comments nor the comments expressed by other persons in attendance today represent the official position of the State Bar, its Board of Trustees, or the State Bar's Chief Trial Counsel. Similarly, the comments and views offered here should not be taken as reflecting the views of the State Bar, its Board of Trustees, or the State Bar's Chief Trial Counsel. No employee of the State Bar can give an attorney permission to violate the Business and Professions Code or the rules of professional conduct.
Okay, so let's go through discipline by the numbers. So, as you can see from the chart, there are over 261,000 licensed attorneys in the state of California. Of those, about 190,000 are active. So we handle complaints against both active and non-active attorneys. As you can see, we get about over 15,000 complaints annually, and we'll go through where those come from, and reportable actions. There's over 2,000 reportable actions a year. Those complaints and reportable actions turn into investigations. We see a little over 4,000 a year against, I want to say against attorneys specifically. So I'm currently on the non-attorney UPL team, so we handle complaints against non-attorneys, so just people who have never been attorneys or resigned, disbarred, or inactive attorneys. And of those complaints, we file notices of discipline in state bar court against about a little over 500. And I think these statistics are from 2016, right? So they're not quite the most recent, but they generally reflect what our office handles.
So the life cycle of a complaint. Complaints start in where we call intake. All complaints in the state of California go through the Los Angeles intake office. Intake reads the complaints, and then they make an initial determination as to how they want to proceed. Most of the complaints are closed flat out because they just don't have merit. For the complaints that do, they forward those to investigations, and then once it's forwarded to an investigation, there's an investigator assigned and a trial counsel assigned, and they decide what's going to happen with the case. If the investigation is completed and they find that there's misconduct, then the matter goes to the hearing department. We have 5 judges in Los Angeles. Actually, we have 6 judges in Los Angeles. We have 3 judges that do the hearing department and another 3 judges that are part of what we call the review department. The review department is like the appellate department, but we have our own court system in the same building as our offices, so we have very little, we don't have to move around too much. So in the appeals department, there are 3 judges, and then if you don't like the result of your appeal, then the next step is to the Supreme Court. So. Why attorneys get into trouble. Most attorneys get into trouble due to ignorance, carelessness, laziness, poor delegation or supervision, lack of office policies and procedures, bad judgment, procrastination, greed. Everybody wants the money. That doesn't apply to you guys here. Stress and burnout, and mental health and or substance abuse issues.
The who and the why. So who complains? Surprisingly, a lot of our complaints come from actual attorneys, opposing counsel, clients, the courts. We get several complaints from judges, non-client members of the public, and then we have mandatory reporters. So those would include banks who are maintaining client trust accounts. In your case, we have seen complaints on dependency lawyers, typically from opposing parties. So, because I think in ladle they represent parents, yes. So it's the other parent sometimes, or you get a parent representing, or for the attorneys that represent the minors, you get the parents complaining about the attorney representing the minors as well. So those are the types of complaints we've seen. So it can be interesting. Obviously, we don't proceed on them typically because again, in intake, we determine whether a complaint is viable. And usually the most viable complaints come from the clients themselves.
Also, for you guys specifically, the complaints come from your clients. I don't get to prosecute any of you guys' complaints because I know too many of you here. So, but the complaints that I have seen is from your clients. My lawyer doesn't call me. My lawyer did nothing for me. They never told me about the hearing. They told me to be quiet, but they never talk about they didn't do their case plan. So, it's really your clients.
Yes, and so that covers kind of the reasons why they complain: lack of communication, failure to refund fees, unexpected outcomes. When you have a contentious relationship with your clients, they're probably going to complain, either here in any kind of circumstance. And we're going to go through more specific examples as we kind of go through.
We're just going to kind of tell you like what happens when we actually discipline attorneys. Disbarment. From 2016, we disbarred 191 attorneys. Suspension, of that 500 that we prosecuted, 202 were suspended with actual suspension or state suspension. The way suspension works is it starts at 30 days if it's actual. State suspension is usually 1 year, which means that your discipline is public. It goes on the website, it goes in the journal, everybody will know, but you don't have to not practice. The actual suspension starts at 30 days and goes all the way to 2.5 to 2 years. So some people get disciplined for 3 years, suspended for 3 years, but our office generally does not do 3-year suspensions. We do 2 years or disbarment. Public reproval. A public reproval is discipline. However, you don't have any type of suspension, but the public will know about the discipline. And we've given out 26 public reprovals in 2016. Private reprovals. An actual private reproval, the only people that'll know about it are you and anybody who looks at your State Bar profile. The difference with a private reproval is it cannot be reported in the journal. So it's not going to go in the monthly journal saying this person was disciplined by the State Bar. We've given out 25 private reprovals in 2016. We also have something called agreements in lieu of discipline. Agreements in lieu of discipline are sort of like a deferred entry of judgment. So you enter into an agreement with us, it is private. If you meet all the terms, it goes away like as if you were never disciplined. However, if you breach the terms of the agreement, then we will discipline you for that and the underlying conduct. We gave 23 agreements in lieu of discipline. And our biggest winner here is warning letters. Warning letters are not discipline. So when someone calls like me, because that is what I do now, I will call you and I'll say, hi, I have a complaint about you. So this is the person who you complained. I'll send you an email, send me a response. I'm going to try to resolve this as quickly as possible. The majority of the time I call you back and I'll say, I'm going to issue you a warning letter. And most attorneys say, oh no, don't do that. I said, okay, well, this is what I found. You violated this rule, so I'll either give you a warning letter or I'll forward it to a disciplinary action. Warning letters are not discipline. So you might want to accept a warning letter if someone calls and offers one to you. It says, hey, we found out that you committed some type of misconduct. However, it's either because it's not a big violation or you've been practicing for a long time and you have no prior discipline. So we're going to say, hey, in the future, don't do this. Maybe you should go to ethics school or trust accounting school and clear this up so we don't have to see you again. So we gave out 534 warning letters in 2016.
Okay, what are the sources of your ethical obligations? The first is the California Rules of Professional Conduct. Now you should all be aware, as of November 1st, 2018, the rules of professional conduct will be re-enumerated, and additionally, they're going to model more after the ABA model rules, and so they're going to have all new numbers, and there's going to be new rules. For example, one of them, I think that was unique to California, was that you cannot engage in a sexual relationship with your client, whereas previously that was not there was no rule against that. There will be now. It will model the ABA rules, and that's just one of the examples, although you may want to have an additional training after the rules come into effect to kind of cover what your obligations are. There aren't many changes, but the numbering will definitely be different. Additionally, the State Bar Act, and there is case law, the California Supreme Court cases and the State Bar Court Review Department cases, which cover your ethical obligations and attorney ethical obligations in California.
There are new rules, though. A lot of the rules were amended. Yes.
Just for everybody's information, our training next week is on the new rules.
Okay.
Great. There you go. You've got it covered.
Okay, the standards for attorney sanctions. The purpose of discipline is to protect the public, to maintain professional standards, and preservation of the public confidence in our profession. As we know, the public is not always confident in our profession, and that is the purpose of discipline, so that the public can be confident in our profession, have confidence in our profession. When we look at the standards for attorney sanctions, we look at the alleged misconduct, we look at mitigating and aggravating circumstances, we look at whether or not a person has a prior record of discipline, state bar discipline, whether there's significant harm to the public, whether this person is engaging in like a pattern of misconduct, and then when we look at mitigation, we look to see, do you have priors or no priors, was it spontaneous candor, did you just come out and say, you know what, I messed up, I'm sorry, let me fix this, do you have, is there a lack of harm to the public or to the administration of justice or to your client? And what we do is we look at all of those things along with the actual standards, because for us, each violation has a standard that correlates with it that says, okay, if you commit this type of violation, this is the range of discipline that can be imposed on a person. But then we also consider the aggravating and mitigating circumstances, and then assign some type of level of discipline. Determining the appropriate discipline for any given case is an art and not an exact science. So not everybody gets the same thing depending on their own unique circumstances. So we do it as a case by case, but we do have somewhat of a range that we stay within.
Okay, so the most common disciplinary violation, or the most common complaint we get is for lack of communication. So under the Business and Professions Code 6068M, attorneys have a duty to respond promptly to reasonable status inquiries and keep the client informed of significant developments. And the Rules of Professional Conduct, current rule 3-500, requires that an attorney to provide a client with copies of significant documents when necessary to keep the client informed. Typically, in the intake department, if we get this type of complaint as a standalone complaint, someone will actually send you a letter and saying, hey, your client complained that you haven't communicated with them in the last 30 days or 60 days or whatnot. Please make sure to contact them within the next 10 business days so that this issue can be resolved. And that's not considered a warning letter, that's just us reaching out to the attorney on behalf of that complaining witness or the client to resolve the issue, because oftentimes all it takes is that letter, a follow-up call, a letter, and typically if you document it, we just resolve the complaint. Most of you will never know, or all of you will never know if there's been a complaint filed against you. All the complaints are confidential. So I know as a State Bar employee, the first thing we do when we start, we look up our own record and see. And you'd be surprised, like, okay, which former clients have complained about me. And for the most part, we close them, as you can see from our statistics. So something like this is something that would be a closure, and if you get that letter, you'd know that there was a complaint against you, but it will never show up to the public, and it would not be considered any sort of violation or anything like that. It's just one of the issues that we try to resolve without any sort of formal discipline and in an informal manner.
And we're just trying to preserve the attorney-client relationship, because once you don't communicate with them, things go downhill. So we try to just say, hey, contact them. However, if you do not, our letter also tells the client that if the attorney doesn't do it within 10 days, call us back, let us know, send us something in writing, and then it will be forwarded to an investigation if you do not call the client back or you do not return the file during that time frame.
And one example, just to highlight the difference of an actionable claim of failure to communicate, is I've seen one where the attorney failed to inform the client of an OSC hearing, where the court was going to determine whether to proceed with the case or dismiss the case, and the client was not informed of the OSC hearing and was not informed that the case was in fact dismissed until after that client went and looked up the case status online. So that would be a viable claim that we would pursue prosecution of that attorney. Another common complaint is failure to perform with competence. A member shall not intentionally, recklessly, or repeatedly fail to perform legal services with competence. We see that this in many ways. So failure to perform services for which they were hired. Typically we see this when an attorney is hired to do some specific act. I've seen one where, for example, an attorney is hired to prepare an expungement, and they did not do so within 2.5 years of hiring. So that is obviously something that we want to investigate. Sporadic performance. Sometimes they're working, sometimes there's no contact or there's no other follow-up. Reckless or repeated incompetent performance. Missing several hearings. Failing to respond to court direction within the specific deadlines, motions, oppositions, etc. Repeated failures to appear, obviously. Failure to supervise, and that includes staff. So we see that leaving non-attorneys responsible for office operations, allowing non-attorney office staff to give legal advice, etc. Failing to file a complaint within the statute of limitations. That's an example of something that we would pursue with investigation, formal prosecution. Failing to oppose a summary judgment motion. Those are all examples of actual violations that we would look into. Now, we also get a lot of complaints related to this if a person loses their motion, loses their hearing, loses their case at trial. So obviously, and I think I've seen one related to a dependency court attorney where, you know, someone's parental rights were terminated and they think that's because their attorney did a bad job. But obviously, that's not the case. Obviously, you guys do all that you can do, but there's only so much that you can do, right? The parents are also in part responsible, and also obviously the court also had a part in what the outcome of their case was. So we look at all the factors typically when we see these types of complaints.
Other common disciplinary violations. This one is not very applicable to you all because you don't usually terminate the relationship. The court does, and then another attorney will be appointed. But we find that a lot of attorneys just withdraw from their clients' cases without ever giving them any notice. They don't allow time for employment of other counsel, and they fail to return the client file or unearned fees, or they fail to account. They'll say things like, it was a flat fee. Well, yeah, it doesn't work like that. Flat fee, when your client fires you, if it was a flat fee, your contract should say something about if the relationship is terminated, this is how much I charge by the hour, and then you have to do the quantum narrowing and then add it up and give them their money back if they have money left over, or take a loss because you've done more work for your flat fee. But those, we get those all the time. People never want to return the money, ever. And we will prosecute that as a standalone, just failure to return unearned fees. We do it a lot.
The other one the other violations are related to client trust accounts. So failure to deposit or maintain client trust funds, commingling, misappropriation, NSF checks, failure to notify client of receipt of funds, and failure to promptly pay out client funds. And probably these misappropriation cases are the ones that are most likely to result in discipline and most likely to result in disbarment. I have one particular example where I have this one attorney, and I won't say who because I don't think it's public yet, but this one attorney was taking on, she had a family law practice, she was taking on clients and advising them to give her large, substantial retainers, so $20,000, $50,000, $70,000 retainers for divorce cases. She also advised her clients to have her hold any expensive jewelry, so she was, you know, entrusted with diamonds, expensive jewels, etc. And then suddenly she had a health issue and she left and she just abandoned her practice. And she said, sorry clients, I can't account any money or anything like that, I have health issues, I'm off the grid. And so she took off. And so that investigation, she did it with multiple clients, so that investigation is still kind of underway, but that's an example of a major misappropriation that we would look into.
Misrepresentations. That's a big deal at our office. There are two types of misrepresentations. You can make a misrepresentation to the court, which would be a violation of 6068, Business and Professions Code section 6068D, which states, employ only those means consistent with the truth and never seek to mislead the court or an officer of the court. The other is a violation of Business and Professions Code section 6106, which states the commission of an act, a commission of any act involving moral turpitude, dishonesty, or corruption, whether acting as an attorney or otherwise. We do prosecute you for misreps that did not happen in your position as an attorney. So if your friend called and said, hey, my friend called me and she said XYZ and that was a lie, and they could prove it, we could actually prosecute you for that. It doesn't have to be in your capacity as an attorney. Moral turpitude, generally, that pretty much means shocks the conscience but no precise definition. We don't really have a precise definition. It's just, should you consciously think that that was something bad to do? But I'm going to tell you how serious the State Bar is about misleading the court and making misrepresentations to the State Bar or to your clients or in your advertisement. I'm going to give you guys a specific example of a case. Family law attorney out of Santa Barbara was representing a client who was in Washington. Client complained that he wasn't doing his job and that he submitted a declaration that she didn't sign. So I call him. I say, hey dude, like, how'd you get your client's signature on this document? So he says, well, she faxed it to me or she sent it to me via email. She scanned it and sent it. And I'm like, well, how did you get it so fast when it's dated before the date that you claim she faxed it, or, well, it was way before the date that he actually sent the declaration to her. So I'm like, I don't understand this. So I call him back and I say, how about this? If I drive to Santa Barbara and I ask for the court file and I look in it, am I going to find a fax or email signature? And he said, yes. I said, I'll call you back. I got in my car, I drove to Santa Barbara, pulled the file. Oh, it's blue. Thank you very much. I called him back and I was like, oh, I told the clerk to hold it for you so you could go look at it too. So, you have a problem. You submitted this declaration to the court. I gave him a 1-year actual suspension for that. But you can't just forge your client's signature, especially if they're unhappy with it. So, big deal. We make that. If the State Bar ever contacts you and they ask you for a written response, don't lie. Just tell the truth, because we will prosecute you for that too. Oh, other common disciplinary violations: failure to obey court orders. Now, attorneys like to disobey court orders. Not a good thing. Willful disobedience or violation of an order of the court requiring him to do or forbear an act connected with or in the course of his profession, which he ought in good faith to do or forbear, and any violation of the oath taken by him or his duties as such attorney, constitutes cause for disbarment or suspension. These orders include oral orders, failures to comply with discovery, failures to pay sanctions if either order is directed at the attorney personally. It includes a joint and several. So what most attorneys in family law court, for some reason, get sanctioned, and they get sanctioned joint and severally with their client. They'll say, well, it wasn't for me to pay. My client was supposed to pay it. No. If your client doesn't pay it by the deadline, you're violating a court order. A lot of people feel like because they appeal a court order, they don't have to comply. That is not how it works. If you appeal the court order and there's some type of money involved, you need to get like a stay of execution on the judgment or go back to the court and ask the court to modify it because you can't afford to pay for it. But if you don't do anything, you're still in violation.
Reporting requirements. So these are all what attorneys are obligated to report to the State Bar. So any felony or misdemeanor conviction, now you should know that a DUI, misdemeanor DUI conviction, actually you are not going to be disciplined at least your first go around. So you get your first if for your purposes. If you ever are in a position where you're charged with a DUI or convicted of a DUI, if it's a misdemeanor and it's your first one, you're probably not going to.
That's not necessarily true.
Well,
as long as there's nothing else.
As long as there's nothing else, yes. It's a standalone, right?
So if it's DUI with your child and you got a DUI, child endangerment, yeah, we're going to prosecute you.
That one, yes. Any felony prosecution, whether or not you get charged, that'll lead to investigation. Impositions of certain sanctions, so those are not discovery sanctions for your purposes. Discipline by another agency or board, so real estate license, imposition of discipline by another jurisdiction, so we've had people disbarred in other states, then you're probably going to get, then we look into it and we have to investigate and see what the discipline will be here. Usually if it's a disbarment in another state, it could lead to disbarment here in California as well. Reversal of judgment based on misconduct, gross incompetence, or misrepresentation. So we're currently, we're currently prosecuting a former deputy district attorney who had prosecuted a murder case back in 1983, and that conviction was overturned only recently, within the last 3 or 4 years, and so that attorney is now being prosecuted by the state bar for prosecutorial misconduct in 1983, because it took that long for it to reach California Supreme Court, and for that conviction, which led to the death penalty, to be overturned, and so that attorney is currently being prosecuted in state bar court. Additionally, the filing of 3+ lawsuits in a 12-month period for malpractice or other wrongful professional misconduct will lead to an investigation, formal investigation, potential prosecution.
Conflicts.
I have a quick questions now or later?
You can take it in the middle.
Either way.
Yeah.
Last year, we had a day in which, through inadvertence and mistake, there was a panic at the courthouse because people thought ICE was coming into the building and were going to start taking away clients. CLC attorneys and some ladle attorneys became very impassioned and were very concerned about protecting their clients from ICE in the courthouse. So there was talk of civil disobedience, there was talk about intentionally hiding clients, there was all sorts of things that were going on around ICE intervention at the courthouse. So I have a couple of questions. Can there be discipline if attorneys are intentionally hiding clients from ICE, if this ever happens in the future? And the second question I have is, if attorneys participate in civil disobedience, either in or outside the courthouse, and they get arrested for whatever resisting arrest, whatever, those are misdemeanor convictions that would have to be reported to the bar?
Yes.
So they have to be reported, absolutely.
Resisting arrest, definitely. We prosecute a lot of resisting arrest cases. We would have to know more of the factual circumstances as to the first scenario. Like, exactly what did they actively do? Did they know that ICE was coming? Because we'd have to look at each individual in each individual circumstance to see, is there some type of moral is that some type of moral turpitude involved? Was this like, is it a crime to do it? So we'd have to look at the actual situation before we could give you an answer. At the bar, almost everything is fact specific for each case.
And then who would bring that complaint? Would the ICE officer bring the complaint? They'd have to name the attorney, so it might, I don't know how that would come to our office. I don't know what that would look like specifically.
Oh, most conflicts can be waived with informed written consent. For you all, conflicts, you do a good job with your conflict checks. You're not going to represent the child and the mother. So, but just in general, most conflicts can be waived by informed written consent. If you were to represent the driver and a passenger in an auto collision, you would need informed written consent. Representing both parties in a divorce case, which I'm not sure most people would think is a good idea. If you have some type of undisclosed relationship with a witness, if you have a waiver, that'll waive that conflict. If you have an undisclosed financial interest, if you have a waiver, that'll waive that conflict. And the consecutive representation of adverse parties. We're starting to see this a lot lately, where an attorney represents one person 8 years ago, and then now they're representing someone else who has a lawsuit against their former client. Now, it's a little tricky because in that situation, the attorney would have had to gain from the first client confidential information material to representation of the second person in that in the new case. So sometimes it's hard for clients to prove that they actually gave that attorney some confidential information. Most clients feel like, she didn't know where I lived, so she couldn't serve me, but the attorney knew my address. You have to look at it and see, like, is that material to the representation? Was that required? Could the attorney have done like a Google search or a Lexis search and gotten her address? Would she be able to find out this information without, despite her representation of the former client? So we're starting to see that a lot. If you ever run into that situation, get a waiver. Inform the client. Hey, former client, I'm representing this person. Can you sign this waiver? New client, I used to represent that person. Do you still want me to represent you? If so, sign this waiver. So that's coming up a lot lately.
But then I think typically our office handles them, a conflicts issue, especially if it's as a standalone complaint, that would probably be resolved with a warning letter, wouldn't you say? I think we discussed in our office how often we prosecute conflicts issues, and I think as a standalone, it generally is not as serious as some of the other issues like we talked about, such as misappropriation. So the next one, other common disciplinary violations, and these are business transactions. So this can also, a transaction and its terms must be fair and reasonable and fully disclosed in writing to the client in a manner which should reasonably have been understood. The writing must have advised the client that they may seek the advice of independent attorney of the client's choice with reasonable opportunity to do so, and the client thereafter consents in writing to terms of the transaction. So this can come up to how Shataka was just talking about moral turpitude, where we see attorneys enter into business transactions that may constitute fraud, right, or unfair, and that may be outside of the attorney-client relationship. So that would be one example. I have one case that I had worked on where the attorney had represented a husband and wife in a personal injury type action and recovered over a $200,000 judgment. Now, I think they were going to get about $180,000. So immediately after the money was recovered, the attorney turned over about $60,000 and then told the couple, well, look, I have this great business venture. I'm going to get you guys even more money. There's a great return on this opportunity, and it's going to be wonderful. And over the next 2 years, they had sporadic payments of $10,000 to $15,000 that was wired to them, not even through his CTA. And so that was obviously an example where we had to investigate further and prosecute. And when we investigate, we are able to subpoena the CTA accounts of the attorney and figure out where the money was going or whether it even went in the CTA to begin with. So that's kind of one example of a business transaction gone wrong. The next one, the unauthorized practice of law. So I currently work on the team, our UPL team, which is kind of a newer project within the State Bar. It's only been around since about 2016. And we investigate allegations of UPL. So unexpected ways an attorney can become not entitled, failure to pay bar dues, so that's kind of an administrative, failure to comply with MCLE requirements, failure to make child support payments, criminal convictions, and failure to pass the MPRE. And that's typically associated with what she was mentioning earlier, ALDs,
or any type of reproval. Anytime you get disciplined, we're going to make you take the MPRE every single time. Whether it's a public reproval, a private reproval, actual suspension, or an a ALD. If you don't pass it within the time frame, then you'll become inactive. So it doesn't work automatically like that. If it's a public reproval or a private reproval, we'll file a case for failing to take and pass the MPRE. The reason why we do that is because when you have a public reproval or a private reproval, it's not approved by the Supreme Court. We don't need Supreme Court approval for that type of discipline or agreements in lieu of discipline. So that could just be approved by a hearing judge. However, if you get any type of suspension, whether it's state or actual, that has to be approved by the Supreme Court. So when the Supreme Court issues its order of discipline, it requires you to take the MPRE. The moment you fail to do it, our review department just automatically makes you not entitled to practice. And so if you didn't look at it and say, oh, okay, I didn't take and pass it, or I haven't checked my state bar profile, and you appeal just one time in court, sit in the attorney section or appear on a case, you will be engaging in an unauthorized practice of law.
Yeah, and obviously attorneys who have been disbarred or resigned and continue to practice law, they're obviously engaging in UPL. So what constitutes UPL? So case law shows that it's not just appearing in court, and you know, I've had that argument. I have a disbarred attorney I'm arguing with right now that he can't maintain his probate practice, but he's like, well, I'm just preparing documents and I'm advising people. That's not UPL, but it's absolutely UPL. So giving legal advice, preparing any document that requires a skill or expertise of an attorney, making court appearances, telling people, holding yourself out as an attorney also constitutes UPL. And surprisingly, we have a lot of these complaints. Currently, I think we have over 300 active investigations of UPL. And our office in LA covers for all of the state of California. Also, attorneys could be responsible for the UPL of others. I'm sorry for the typo here. During the loan modification crisis, we had a lot of attorneys who opened multiple offices in different counties all around LA, but they had paralegals or other support staff running those offices. So that was UPL, although we were able to prosecute them based on their fraudulent business practices of engaging in or offering loan modification services. Leaving that non-attorney staff in charge of those offices would have also been cause for, is essentially helping, aiding the UPL of others. We also handle non-attorney UPL, which is also very frequent. So in our office, what we can do, we can issue cease and desist letters. We also work with law enforcement to make criminally or civilly prosecute the non-attorneys for engaging in UPL. And we can also request orders to assume jurisdiction over the unauthorized law practice. I just obtained one of these orders in Orange County against he was a jailhouse lawyer. He had been in prison for about 8 or 9 years. He came out, he founded a nonprofit to help other inmates as they transition back into the regular world from prison, except that he was actually advertising and offering post-conviction services to inmates across the country. And unfortunately, he had hired attorneys in the process to help with the research and for handling these inmate matters. And we've recovered about 600 files. So once I got the order, we get an order to assume jurisdiction over his practice. We shut down his phone lines. We redirect it to the state bar. We redirect all mail. We can recover, we froze all of his bank accounts. We were able to recover any files that were in his office that day, and from the bank accounts we found out that he also had a public storage unit just a block or two away from the actual office. So we got an order to go back into the public storage and recover all client files and business records from that office. And unfortunately, in those business records he had about 7 or 8 attorneys who worked for him, and some of their contracts indicated that they were well aware that there was fee splitting going on, that they were aiding UPL, and so we now have open investigations against those attorneys. So it can be very time consuming, and additionally we now have the Orange County DA is going to formally prosecute him for his criminal work. Unfortunately, he's since relocated to Nevada and trying to set up shop there with a new name and a whole new operation, and so we're working with the Nevada law enforcement authorities so that they can prevent that before it even happens. But that's kind of what our office does. Right. Right.
Prosecuting him and give him a lot of good.
Criminal convictions. Discipline for conviction involving moral turpitude or other misconduct warranting discipline. This includes DUIs. It depends on what the elements of the crime deemed proved by the conviction, and disciplinary trial regarding the facts and circumstances of the offense. Which that means if it's a DUI, normally if it's just a DUI, then we would just prosecute the DUI. However, say it's a petty theft, but somehow they have a great attorney and they get it down to like a trespass. Well, I'm not going to prosecute you for the trespass. I'm going to try to prosecute you for the petty theft because that involves moral turpitude. So I'm going to put on a trial that says, hey, although she was convicted of trespassing, this is really a theft and it involves moral turpitude, and that's going to get you more discipline. So we do look at the underlying facts of the case and go beyond what the actual conviction might be. If you're ever convicted of a felony that involves moral turpitude, we have what's called summary disbarment. Summary disbarment is for felony convictions where elements of the offense is specific intent to deceive, defraud, steal, or make a suborn, or make or suborn a false statement, or if the offense involves moral turpitude per se. If you are arrested for a felony, interim suspension is imposed for any felony or misdemeanor involving moral turpitude per se. So what happens is if you are arrested for a felony or a misdemeanor involving any felony or a misdemeanor involving moral turpitude per se, our review department is going to put you on interim suspension even before your conviction is final. They're going to say you cannot practice right now. So when this is all over with, if you're convicted of a misdemeanor involving moral turpitude per se, then we'll probably prosecute you for that. If you're convicted of a felony, we'll prosecute you for that. You'll get credit for the time you were suspended. However, if it's a felony involving moral turpitude per se, you will be summarily disbarred as soon as the conviction is final.
How would you find
No
out?
trial. Oh, they send a notice. They send it, what we do is, courts are required to report every time an attorney is convicted. So if you're an attorney and they arrest you, which I got a referral from, I can't remember what county it was, Riverside County, where they were prosecuting an attorney for, I think it was like 57 counts of embezzlement. So he got an interim suspension. So once they reported it to me, I reported to our conviction monitoring unit, and then they monitor the convictions. Other times we find out just because a client might call in and say, hey, I can't find my attorney, and somebody said he's in jail, then I'll just look you up. And then we go from there. So the DA's office is not always the best about reporting things, but the judge is required to report it too if they know that you're an attorney.
Yeah.
So all of these people are supposed to report it. Doesn't always happen. Sometimes you find out late. But if you were going to be summarily disbarred, the review department would send you. We would transmit a summary disbarment to our review department. They would look at it, and then they'll make a decision on it once the conviction is final, and then that's it. You'll be summarily disbarred very shortly after.
But I think going back to this, I also want to mention, so all of you were recently fingerprinted for the State Bar. One of the issues that we found was that when people were being arrested, they self-declare their occupation. So even though they may be a licensed attorney in California, they were saying, oh, well, I'm a business owner, or I'm a real estate agent, or some other occupation, and in that case, we wouldn't know until after the fact. If it later comes up, we find out that they also have an attorney to practice law in the state of California. And so that's something that...
So we'll get a huge increase of cases for criminal convictions.
Right,
soon.
based on, the re-fingerprinting issue. All right, so State Bar resources. So if you're ever in a situation where you're questioning whether something is ethically ambiguous, you have the ethics hotline, where we will not necessarily advise you of what to do, but you will be directed to the resource, so the appropriate rule, possibly case law, to review for your certain situation. We have membership records for notification or change of address. You can also notify membership records if you're ever the subject of identity theft. So in NAPL, we find that attorneys may get a call from a client that they never knew they had because someone is using their bar number or name if they have, a very common name sometimes. And you can also notify membership records for that issue. Also, the Lawyer Assistance Program, which is confidential, includes resources for mental health, alcohol, or drug abuse-related issues. And I think we have that up there. Additionally, there are several resources on the State Bar website. So we have free online resources, so you can look up any advisory opinions that the State Bar has issued related to several ethical issues. The Client Security Fund, which pays essentially restitution to clients of attorneys who have been disciplined by the State Bar. Additionally, it's not on here, but if you have a complaint against another attorney or a non-attorney, you can find the complaint form, and you can now submit a complaint online through our website, which has not been the case for the last several years, surprisingly. There's the Ethics Handbook on Client Trust Accounting, Rules and Statutes, Information on Legal Specialization, and How to Close a Law Practice, although that won't necessarily apply to any of you. And then we offer two resources for your purposes for completing MCLEs, and that's State Bar Ethics School, which is a one-day training, and we also have State Bar Client Trust Accounting School, which is a half-day training, which will also satisfy your MCLE requirements. You can check our website if you're ever interested in attending. Those can be mandatory, so some of the people that attend those, that's part of their discipline. So
lots of people are mandatory. And it's weird because as a senior trial counsel, you have to teach ethics school. So I'm teaching ethics school the last session in April, and someone I prosecute sitting in the audience, and I don't want to call her by her name because I don't want everyone to know that I know her. Sorta know her, but she kept Shores-Brools. So and she would do stuff that was so specific to her own case, and then I'm just like, yeah, I can't answer that question. But it's strange because the same people who teach ethics school are the same people who prosecute the people who attend ethics school. So it gets a little weird.
But you can attend as someone who hasn't been prosecuted by the state bar if you want to satisfy your MCLE requirements as well. And so this kind of concludes. I guess we'll open up for questions if anyone has questions. Yes?
So do I understand correctly, it's not okay to threaten to file a complaint against an attorney if you're an attorney, but it's okay to actually file the complaint against the attorney if you're an attorney?
Did you say threaten to file? Oh yeah, do not do that. Just file it. Don't threaten to file it because
No notice involved.
Well, the rule specifically says
if it's to gain an advantage in a civil dispute.
Right.
So there has to be some type of civil dispute, but it doesn't mean that it has to be filed in court. If you guys just have some disagreement about something, then don't threaten to file the complaint, just file it.
Just file a complaint. Yes.
If a client filed a complaint against us and it went nowhere, would we ever find out about that? Would we ever get notice?
No.
So when does the state bar actually contact the attorney regarding a complaint?
Once we determine that it has possibly some merit and we need to know the actual answer to something, like we need you to respond to say yes or no, you did not do something, that's when you would know, when it goes to the investigation stage, never at the inquiry stage, unless it's a return of file or call your client.
So how would you determine, I guess, as the investigator, the person screening what has merit and what doesn't?
It depends on the facts that they give in their complaint. So anytime somebody says my attorney stole my money, it's not closing. We have to actually look into it to find out if the attorney stole their money. But if it's something like, I have a case right now where the attorney didn't do anything. The clients are like, the complaint actually says, my attorney lost my case because they entered default because we didn't get notice of a deposition. So I'm like, yeah, we can't really close that because that doesn't make any sense. You don't default because you don't show up to a deposition. What I ended up finding out was that he didn't oppose any of the motions to compel, he didn't comply with the discovery, he didn't respond to the motion for terminating sanctions. There was an OSC where the court ordered for his clients to show up at a deposition on a specific date. He never told them about it. He called opposing counsel the very day before the depositions and said, we can't make it. His clients had no idea. They go for a motion for terminating sanctions, which he doesn't appear for the hearing, and then the court says, okay, because you didn't do any of the things that I told you to do and you violated my court order, I'm striking the answer. Once the answer is stricken, a default is entered. So he failed to perform in a whole lot of other things. But those are complaints where when I'm like, I really don't know what's going on here, let me look into it, it's going to move to an investigation. At that time, the attorney will be contacted with a letter saying, hey, can you explain what happened here?
And typically, for your purposes, if we get a complaint from a ladle client, they will have to provide documentation. So they can't just say, oh, my attorney ruined my whole case, they didn't do this, X, Y, and Z. In civil cases, we're able to look up what's going on. Some counties have all the minute orders. We can look up the case summary. We can find out what the deadlines were when hearings are being held. But in your cases, they're confidential, and so we'd ask the clients to give us more information. Give us copies of letters between the attorney and you. Give us any documentation, minute orders, etc., to show us what exactly is going on. So we ask for the full picture before we investigate anything. And if they're not able to provide those things, then we don't have any basis to proceed or investigate the claims that they're making or the allegations.
Ladle complaints, a lot of ladle complaints come off of the fact that they claim that you guys didn't tell them they had 60 days to appeal and that you didn't give them the right time frame for a writ, whether they were in person or not in person. So that's what a lot of the ladle complaints come from. So they'll just say things like, my attorney never told me, and then I said I wanted to appeal, and they said, oh, you missed the deadline by 1 day. So they get a lot of complaints like that. Then we might contact you and ask you, hey, do you have any proof that you notified your client that they had the right to appeal within this time frame?
Yes.
For the lack of reasonable communication, you said that there's the requirement for providing the client with copies of significant documents. Is significant defined anywhere, or is that kind of just your judgment if it is a substantive change in the case?
If your client asks you for a report, you probably should give it a copy of the report. Because to them it might be a significant development in there, or they might think that it is. If their reunification services are probably going to be terminated, that might be a significant development, so you might want to give them that report. But there's no definition of it.
Yes?
Is it misrepresentation if you don't tell law enforcement that you're an attorney?
It depends. If you can only misrepresent something that you actually say.
So if they ask you if you're an
if they
attorney?
ask you and you tell a lie, then yes.
But people have gotten around that because typically, you know, when there's an arrest made, they ask, well, what's your occupation? And I remember one example, one guy said he's a record producer because he had a record company, but he's also a licensed attorney. And so technically that wasn't a lie, but it was like a half-truth, and it was...
What if you refuse to answer?
And you can't misrepresent what you didn't state.
Right. Any other questions?
Yeah, just briefly, we deal with people sometimes that have mental health issues, and I guess I'll just wrap myself out here. I got a complaint filed against me by a person who has obvious mental health issues. How does the bar look at that?
Well, we have to know that they have mental health issues, and we have to look at the actual complaint. Just because someone has obvious mental health issues doesn't mean that their complaint has no merit. So we have to look at the facts and circumstances and make a determination.
Well, I get that letter that you're talking about. It just says contact them within 10 days, but even that was false because, you know, she was saying I had spoken to her. She'd been to court multiple times, and I guess it's not that big a deal, but still for me to get one of those letters, and I had only been working here like a month.
I'm sure it was very alarming.
To me, to get a letter from the state bar, although it did say we consider this issue closed, and, you know, I gave it to my, you know, firm director, and thankfully she helped me out. But,
Right.
you know.
So it's good to know that those letters obviously don't go against you. We recognize
You
that...
keep track of those, like if I get another one.
No.
I deal with a lot of crazy people.
Right, no, we understand, we recognize, we've seen several complaints from, we call them, you know, people that are, just submit complaints weekly, daily. We get complaints from certain people that we recognize have mental health. We can recognize that in some cases, but we still have to address the issue. And it's always best if you follow up with a letter dated within 10 days of that date that you received the state bar letter, and just so that you have a record of it, because that person obviously can come back and say, well, I never heard from them. But if we have a letter with the address that you have on file for them, then you've covered everything. Yes.
I was just gonna follow through with two things real quickly, which is the proviso for the attorneys, documentation,
Yes.
documentation, because should they ever call in the 11 years or so far in our firm, the only time an investigator ever called one of our attorneys is because the attorney got a letter from the bar, and I think it was because it was a client that had mental health issues, and the investigator was investigating to see whether the client had mental health problems or if they were just checking out, and the attorney saw the letter and freaked out and never responded.
Oh, that's a standalone right there.
So now you get the letter from
Yeah.
the investigator, because now they're really like, if you don't get back to me with a certain amount of time, they're gonna take it up. And that's when the attorney, and I sat with the attorney, and the investigator asked some really just regular, and we had everything documented, so we could tell the investigator everything they needed, and it was done. But don't ignore.
Right. Yeah,
Actually, the
there's
Business
a
and
rule.
Professions Code
6068.
6068I
Yes.
says you have a duty to comply and cooperate in a state bar investigation.
Absolutely.
Now, we have cases where the complaint ends up with no merit, but we still file because the attorney didn't cooperate. And there's a lot of people in our office who will prosecute that as a standalone charge only.
Yes.
But going off of Chad's question, as dependency attorneys, we deal with a really unique segment of the population. So do we, as dependency attorneys, do we get some sort of leniency?
No, we're all held to the same standards.
Yes, but we recognize, I came from the Legal Aid Foundation of Los Angeles, so I have a legal aid background, and working in one of the offices, all my clients had mental health issues. So I understand exactly where you're coming from. And our attorneys, we have a whole group of attorneys in intake who have a variety of backgrounds, and then they all discuss, and they all have different backgrounds as well. And so it's a very collaborative environment where if we have an issue with a dependency lawyer, we'll go to Shataka or someone else.
But they don't tell me who.
We don't tell you the
because
names, right. And
I don't want to know.
Right. But we recognize the issues that come into play in your specific area of practice. Any other questions?